we need more time? Oh, right, okay. Do you want to resolve that now, or should... Okay. Well, thank you for that. I think, say with Candice, I think it's over to you now to pick up the rest of the submissions for the respondent. Thank you.
Thank you, Mr. President. Mr. President, members of the tribunal, if you disagree with us on our objections to jurisdiction, then you'll want to look at the expropriation process. Costa Rica's position is that it acted in good faith at all times to regulate the use of land in the park to protect the nesting habitat of the leatherback sea turtles, while respecting landowners' rights. Each of claimants' claims is without merit. Costa Rica's actions are fully consistent with its obligations under CAFTA. In the interest of time, I will keep my discussion of the legal issues limited. The tribunal may refer to paragraphs 175 to 229 of Respondent's rejoinder on the merits for a more detailed discussion of Costa Rica's legal arguments. Claimants allege that Respondent has breached its obligations under Article 10.7 of CAFTA. Article 10.7 of CAFTA provides that, quote, no party may expropriate or nationalize a covered investment, either directly or indirectly, through measures equivalent to expropriation or nationalization, except, quote, for a public purpose in a non-discriminatory manner on payment of prompt, adequate, and effective compensation, and in accordance with due process of law, close quote, and in the minimum standard of treatment. Each of these elements has been met in this case. Respondents' efforts to expropriate the 75-meter portion of claimants' properties that are within the park's boundaries are and have been fully lawful and under international law and under municipal law. Article 2 of the 1995 Park Law expressly provides Costa Rica the authority to expropriate all such lands, and Respondent is now carrying out that expropriation with respect to certain of claimants' properties consistent with its obligations under international law and municipal law. I will now briefly describe Costa Rica's expropriation procedure and the status of each of claimants' properties in those proceedings. And if you turn to slide 21, this is a flow chart which describes the expropriation procedure under Costa Rican law. The expropriation procedures in Costa Rica are governed by law number 7495. Respondent and Mrs. Georgina Chavez, who will testify at this hearing, have already described in detail in the written pleadings the steps Costa Rica must take in order to expropriate private property. I will only summarize briefly now the process. The expropriation procedure is designed to protect the owner's rights of due process at all times. The procedure is divided into two stages, the administrative stage, which is on the left, and the judicial stage, which is on the right. As you can see in the flow chart on the slide in front of you, the administrative stage begins with a declaration of public interest. The judicial stage begins with a decree of expropriation. At the administrative stage, the National System of Conservation Areas, or CNAC, is the entity that decides to initiate the expropriation proceedings. At this stage, an administrative valuation is issued. The owner may accept or object to that valuation. If the owner accepts the valuation, the state will pay the amount awarded and title to the property will pass to the state. If the owner objects to the valuation, CNAC issues a decree of expropriation and sends the file to the Procuraduría to initiate a judicial proceeding to determine the fair market value of the property. At that time, MNI must deposit the amount of the administrative appraisal into an account with the court. The owner may take the amount of this amount at any point in time. Up to this point, the owner can fully use and enjoy his or her property. The state may take possession of the property 2 months after the initial deposit of the administrative appraisal has been made. With the state taking possession of the land, the property owner then loses possession, but not title to the property. The property owner does not lose title to the property until after the court has issued a final decision and the fair market value on the property has been made. Costa Rica's expropriation procedure gives the owner several safeguards. First, the court must determine the fair market value of the property based on evidence submitted by both parties, the owner of the property and the Procuraduría, who represents the state in these transactions. Second, the amount awarded cannot be lower than the administrative amount that's been appraised. And third, the judge's decision may be appealed by either party. So thus the owner has not one, but two opportunities to appeal the value of the award as compensation for the expropriation. And Costa Rica has followed this procedure with respect to all of claimant's properties that have been subject to expropriation and that are at this stage. Please turn to slide number 22. Claimant's properties are in 3 different stages in the expropriation procedure. The first category is properties where no declaration of public interest has been issued. 8 properties fall into this category. They are lots A39, SPG 3, C71, C96, V59, V61A, V61B, and V61C.
May I just ask you, you said no declaration of public interest, and your slide says declaration of public interest. Is that a typo, or have I just misheard?
Sorry? It is a typo. Yeah, no declaration. It should say no. It is a typo in the slide, and I apologize. Thank you for the.
It should be no.
It should be no declaration of public interest. Thank you for catching that. The second category of properties is where a declaration of public interest has been issued, but where there is no decree of expropriation. These are the properties where expropriation procedures were suspended at the administrative stage, but before the properties were transferred to the judicial stage. And 9 properties fall into that category, and they are listed there. Lots V30, V31, 32, 33, 38, 39, 40, 47, 46, and 47. The third category of properties is where the decree of expropriation has been issued, and thus the properties are in the judicial stage. And 9 properties fall into this category. They are A40, SPG1, SPG2, B1, B3, B5, B6, B7, and B8. So I will discuss the status of properties in categories 1 and 2 first, and then I will discuss the status of properties in the third category. As we've explained in our written submissions, the expropriation of properties in the first and second categories, that is, properties that have not yet reached the judicial stage, are currently suspended until CNAC completes the implementation of recommendations from the Contraloría, which was issued in 2010. The Contraloría is Costa Rican government's inspection and oversight agency. Its recommendations are binding on the entity being supervised. In 2010, the Contraloría recommended that CNAC and other government agencies take several actions to improve the expropriation procedures of properties inside the park. To date, CNAC has completed 9 of the 13 recommendations and is working to complete the remaining recommendations as soon as possible. When this process is finished, Costa Rica will continue with the expropriation procedures and pay property owners compensation awarded by the Costa Rican courts. For those properties that are in the administrative stage, claimants will have the opportunity to request an updated administrative appraisal or to continue directly into the judicial stage of expropriation procedure. Properties in this category, or these 2 categories, have not yet been expropriated, directly or indirectly. First, the suspension of the expropriation procedures do not themselves constitute a taking. According to Costa Rican law, claimants may still enjoy use or dispose of their property as they please. Thus, the properties are practically in the same position that they would have been, where they were when they bought the land. They are inside the park with the possibility that they will be expropriated. Contrary to claimants' allegations, Costa Rica never redrew the boundaries of the park. Instead, the claimants bought properties hoping that Costa Rica would redraw the boundaries of the park or change its protected status, but it did not. Claimants also alleged that the definite suspension of all environmental permits by SETENA accounts for an indirect expropriation under Annex 10C of CAFTA. If the tribunal were to decide that it has jurisdiction to hear this claim, even though the suspension was adopted before CAFTA came into force, this measure was taken to safeguard environmentally fragile area of the park. As such, it is not an indirect expropriation, as provided under Annex 10C of CAFTA. Specifically, Article 4B of Annex 10C provides that, quote, except in rare circumstances, non-discriminatory regulatory actions by a party that are designed and applied to protect the legitimate public welfare objectives, such as public health, safety, and the environment, do not constitute indirect expropriations, close quote. Thus, the suspension of the environmental permits does not constitute an indirect expropriation. Please turn to slide 23. Let us now consider the status of the properties in the third category. These are the properties that are at the judicial stage. To date, a final judicial decision on compensation has been issued for 6 of the 9 lots. Lots A4, SPG2, B3, B5, B6, and B8. Claimants allege that these properties have been directly expropriated. However, claimants have presented different arguments regarding exactly when that expropriation has occurred. In their memorial on the merits, claimants argued that expropriation occurred at the moment the state took possession of the property, and this occurs when an act of dispossession is issued. If this were true, then all their claims would be outside of the tribunal's jurisdiction because the state took possession of these properties in 2008. In their rejoinder on jurisdiction, which is their latest submission, claimants changed their argument to argue that expropriation occurs when the state takes title of the property. That was at claimants' rejoinder on jurisdiction at pairs 4 and 153. But members of the tribunal, if you were to accept this argument, which they reiterated today in their opening, their claim is not ripe with respect to 6 of the 9 properties that are in the judicial stage because there has been no title that has passed for those properties. In any case, with respect to the 3 properties, A40, B3, and B8, for which there has been title that has passed, respondents' actions have been fully consistent with its obligations under Article 10.7 of CAFTA. As I discussed a short while ago, Article 10.7.1 provides that no party may expropriate or nationalize a covered investment directly or indirectly through measures equivalent to expropriation, except for a public purpose in a non-discriminatory manner, on payment of prompt, adequate, and effective compensation in accordance with due process of law. Each of these elements has been met in this case. First, Las Balas National Park was created for a valid public purpose. As Mr. Alexandrov discussed in detail earlier today, the creation of the park, and in particular the inclusion of the 125-meter strip of land along the coast, was necessary to protect the fragile nesting area of one of the most endangered species in the world, the leatherback sea turtle. This is supported by scientific evidence, international organizations, and the Costa Rican authorities. Second, Costa Rica has not acted in a discriminatory manner while expropriating claimants' property. Claimants have not submitted any evidence to support this statement. In fact, Costa Rica has a detailed plan concerning expropriations and will expropriate all property located inside the park without consideration as to whether the landowner is foreign or not. And those plans are at Exhibits R009 and R010. Third, Costa Rica has provided or is in the process of providing prompt, adequate, and effective compensation. Costa Rica has also paid compensation without delay, equivalent to the fair market value of the expropriated investment, before the expropriation took place, and has not reflected any change in value occurring because of the intended expropriation had become known earlier. This is perhaps the point in where there is the most contention between the parties. But as Costa Rica has explained in its written submissions, and as claimant now argues, under Costa Rican law, an expropriation has ripened when title passes to the state. This occurs after the final judgment of fair market value for the property is rendered and executed. And around that time, payment of the amount awarded by the court is made available to the landowner. It happens at the same time almost. Claimants themselves admit that prompt payment occurs when compensation has been paid at the time of the taking. And thus, under claimants' own definition of prompt payment, Costa Rica has complied with this obligation. For each of the three lots, A40, B3, B8, Costa Rica has made available the principal awarded by the court, including the amount of administrative appraisal, before title passed to the state. Lot A40 has requested and received payment of the principal and legal interest. Lot B3 has requested and received payment of the principal. Lot B8 has yet to request payment of the principal, and therefore no payment of principal has been made. In the Costa Rican system, in order for the individual property owner to receive the payment, they have to make a request to the state. Lots B3 and B8, payment for legal interest is being processed. Now, with respect to claimants' allegations that the amount awarded by Costa Rica is not equivalent to the fair market value, or that compensation has not been adequate, claimants' evidence is unreliable. Claimants base their allegation on FTI's expert report. However, FTI's reports are overstated, and as I will discuss in greater detail a little bit later. In addition, claimants are asking this tribunal to act as an appeal court. Claimants are asking you to second-guess the decisions made by the domestic courts. Finally, ample due process has been provided. Claimants have had opportunity to present their arguments to defend their interests throughout the entire expropriation procedure. As I discussed, there are several steps along the way in which the claimants, in which the property owners are able to appeal a decision or ask for a different decision. Thus, there is no merit to claimants' allegations concerning expropriation. If you turn to slide 24. In their first two written submissions, claimants limited their allegations to claims of Costa Rica contravening claimants' legitimate expectations and acting in an arbitrary manner. But in their rejoinder on jurisdiction, claimants have a new claim with respect to denial of justice. Each of these claims is without merit. With respect to legitimate expectations, Article 10.5 of CAFTA provides for the minimum standard of treatment under customary international law. As Respondent has explained in its written submissions, the minimum standard of treatment under customary international law sets a very high standard, or a very high threshold. In other words, the measures need to be sufficiently egregious or shocking to fall below that accepted international standard. This interpretation has been supported by the tribunal in the Glamis Gold versus the United States case, when interpreting a similar standard of treatment under NAFTA. Respondent also argued that other tribunals, such as those at Merrill and Ring versus Canada, International Thunderbird Gaming Corporation versus Mexico, and ADF versus the United States. In those cases, they have also interpreted the minimum standard of treatment, and they've interpreted it to exclude the protection of investors' legitimate expectations unless there's been an action by the government inducing the investor to invest. And in this case, Costa Rica has never induced or invited or prompted claimants to buy their properties. Thus, claimants' legitimate expectations are not protected under CAFTA. However, even if the tribunal were to find that claimants' alleged legitimate expectations were protected, claimants could not have legitimately expected that their land was outside the park or that it would not be expropriated. Please turn to slide 25. This is the timeline slide that you have seen before, earlier today, and a brief review of the chronology of events prior to claimants' investment shows why claimants' legitimate expectations claims are baseless. In light of claimants' knowledge before they purchased their properties, there is simply no basis for claimants to assert that they had a legitimate expectation that their properties would not fall within the park boundaries. All of the properties were already in the park when claimants purchased them, or that the state would not expropriate their claimants' land. They were, in fact, entitled to do so under the 1995 park law. The truth is that claimants were hoping that none would occur, that none of this would occur, that none of their properties would be taken. And in their opening, they were mentioning the legislative acts that were being considered, but in the end, those legislative acts that would have changed the rules or the law with respect to where the park boundaries were never were passed. So claimants hoped that that law would change. They hoped it would be such that they would not, their land would not be in land that would be expropriated. They took a chance, but they lost that chance. The law stayed the same. Claimants' alleged expectations to the contrary are just simply not legitimate. Members of the tribunal, this takes us to claimants' claims of arbitrariness. Claimants complain about variations in property valuation. However, there is nothing arbitrary about such valuations. The parties agree that the applicable standard to determine whether a state's conduct is arbitrary is the one set forth in Elsie case. In Elsie, the ICJ held that an arbitrary act, quote, is not so much something opposed to a rule of law as something opposed to the rule of law. It is a willful disregard of due process of law, an act which shocks or at least surprises a sense of judicial propriety, close quote. That's at paragraph 128 of the Elsie Award. As the facts show, the Costa Rican courts have followed the provisions of the expropriation law to determine the valuation of the properties. Judges decide the valuation depending upon the evidence presented to them and the arguments presented to the parties. And when the judge is making a consideration, they have at least two, can have in front of them at least two valuations that are put forward by them, one by one party, one by the other party. And so they have a lot of evidence that is put before them, and they consider all of that evidence when they're making their decision. The fact that judges come out, or the decisions, the valuations come out differently is not a surprise. It depends upon the elements and the facts that are before the judge when they're making that decision. So there's nothing inherently arbitrary about this process. And it's intended to give rights to both parties in trying to determine what the final value should be for the property. Finally, claimants allege that in the course of this arbitration, that they learned of a new measure adopted by Costa Rica that constituted a breach of CAFTA's provision. This so-called new measure is the temporary suspension of expropriation procedures adopted by CNAC in order to implement the Contraloria's recommendations that I discussed a little bit earlier. These recommendations are aimed at improving the expropriation procedures related to Las Baldas National Park and guaranteeing landowners' property rights. In their rejoinder on jurisdiction, claimants allege, for the first time in these proceedings, that the suspension was adopted to further delay payment of compensation to claimants and that the delay in payment constitutes a constructive denial of justice. Members of the tribunal, this claim is untimely. First, claimants cannot raise a claim in the middle of an arbitration proceeding if they did not include it in their notice of arbitration, nor may they raise an argument on the merits of this new claim, in particular on a rejoinder on jurisdiction. So not only is it at the very end of the proceeding, but it's even in a time in which they are not supposed to be discussing issues on merits. This is a rejoinder on jurisdiction. This issue is a merits claim. Respondent has not been given time or an opportunity to properly respond to the claim. Thus, the claim should be excluded from this arbitration. Second, it is not a new measure. But with respect to the alleged delay of payment of indirect expropriation, this corresponds to the lingering effects of the measure that was adopted by CAFTA before CAFTA came into force. Therefore, before 2009, Costa Rica had no international obligation to pay promptly, as Mr. Alexandrov had explained earlier. Let me now turn briefly to the issue of damages and claimants' damages claims. Respondent maintains that it has acted in accordance with its CAFTA obligations at all times. Thus, the tribunal should not award any damages beyond those that claimants have already received or will receive through the expropriation procedures in Costa Rica. At this point, claimants have already received or will receive once requested by them the value of colones 1,706,180,610 colones. And that's for the 9 properties that are at the judicial stage of expropriation. And claimants will receive fair market value for each of the remaining 17 properties that the government will expropriate. However, if the tribunal were to determine that Costa Rica has breached obligations under CAFTA and award claimants compensation accordingly, it goes without saying that any amounts claimants have received in the domestic legal proceedings must be offset against any award. In addition, if the tribunal were to award damages based on the value of property, claimants must be required to surrender that property to the state without further court proceedings. In their reply, claimants agreed to both of these requests. That is, claimants agreed that any amount that has been paid to them should be offset by, against any final amount awarded and by the tribunal, and that they will surrender title to the property to the state if the tribunal were to award damages on the value of their property. So on this point, the parties agree. Claimants seek a total amount of damages of $59,484,100, which is comprised of $36,543 of value in their allegedly expropriated properties and $22,941,100 in interest. These values, as I will discuss momentarily, are grossly overstated. But I want to mention one thing at this moment. Counsel for claimants had said in the opening statement that this is the only appraisal report that's on the record, and this is not true. First, there are many appraisal reports that have been made with respect to these properties. There are the administrative appraisals, the judicial appraisals, and there are two within the judicial appraisals for each of the processes. There are the judicial proceedings and then the final judicial decision. In addition, Respondent's damages expert has in his second report at paragraph 130 identified a value for the properties if the tribunal were to agree or accept the prices that have been put on the record as the price that has been paid for the properties. And that amount is $4,529,490. So there is an alternative amount that is before you. Claimant's principal complaint is one of wrongful expropriation. According to CAFTA, compensation for a breach of the expropriation provision is equal to the fair market value of the expropriated investment. This is at Article 10.72b of CAFTA, which is Exhibit C1a. The date of the valuation is to occur, quote, immediately before the expropriation took place, close quote. But rather than valuing the fair market value of the expropriated investment immediately before the expropriation took place, claimants seek to base the value of their properties on a but-for scenario that ignores the fact that their properties are located in a national park. But in fact, as discussed earlier, claimants knew or should have known when they purchased their land that they were purchasing property within the park, and therefore their land was subject to restrictions and eventual expropriation, and that would negatively affect the value of their investment. Thus, if the tribunal were to value claimant's investment, Respondent respectfully requests that the tribunal take into consideration the fact that claimant's properties are currently located in the park and were located in the park on the date the claimants purchased them. Each of claimants purchased their properties at a significant discount because the properties are located in the park. Therefore, awarding claimants anything more than they originally purchased for them would give claimants an improper windfall. The most claimants should receive, if the tribunal should find that they should receive anything at all, since they will eventually receive fair compensation through the expropriation process, is the price that claimants paid for the properties. In fact, no damage should be awarded at all because claimants will receive fair and adequate compensation for the properties that Costa Rica expropriates. Claimants will actually receive more than fair market and adequate compensation through Costa Rica's expropriation process. To wit, some of claimants' properties that have been completed in the judicial stage of expropriation are receiving a surprising amount more than what they paid for them. For example, Spence Company, which will receive 697,625,900 colones for the portion of lot SPG2 that is being expropriated. That portion of SPG2 cost Spence Company $14,297 colones. Thus, Spence Co. received 721% more from the government of Costa Rica for that property than Spence Co. originally paid for it. In the case of Lot B8, as another example, based on the evidence that's currently on the record, Mr. Berkowitz will receive 326,078,368 colones for the portion of the property that was being expropriated. That is a whopping 171,398% more than the 190,136 colones it cost him to purchase that property based on evidence on the record. Claimants' damages claims are overstated and undeserved for other reasons as well. In this respect, Respondent's damages expert, Mr. Kaczmarek, has identified a number of fundamental flaws in claimants and their real estate appraisers, FTI's, approach to the valuation of claimants' properties. First, FTI ignores the reality of the real estate market in Guanacaste at the time that the alleged breach occurred, and that is May 2008, and the reason why I select that date is because that's the date the valuation has been made by Mr. Hedden. As Mr. Kaczmarek explains in his report, the Costa Rican market underwent a boom in the early 2000s and a bust in 2008. FTI ignores this fact completely. Second, with respect to the properties that are partially expropriated, FTI argues that claimants should receive damages for both the portion that was expropriated and the portion that is not expropriated. This is their severance damages claim. But FTI's claim on severance damages does not make any sense. They are attributing beachfront value to the entire lot subject to partial expropriation. FTI claims that the portion of the property that was closest to the beach was expropriated, and therefore the remaining parcel has lost its beachfront value. So not only should the expropriated portion be valued at beachfront property, but the remaining portion that is also no longer considered beachfront property. This is true even though it is now, after the expropriation, the property closest to the beach. And the truth is, as for beachfront value, or so-called beachfront value, there never really was any beachfront view or access to lose. This is because of environmental regulations that prohibit the removal of vegetation that borders and covers access to the beach. Finally, FTI employs comparable sale approach in its property valuations. It analyzes similar properties and sales of similar properties to claimants' properties in order to determine the value of claimants' properties. Yet none of these transactions or properties it uses are comparable or appropriate. And for these reasons, FTI's analysis is unreliable. Mr. Kaczmarek will discuss this more flaws in detail in his expert testimony later this week. In sum, claimants' damages claims are grossly overstated and unreliable. Claimants are reaching for every cent that they think they can squeeze out of this arbitration, and in so doing, they have raised serious doubts about the credibility of their damages claims. For the foregoing reasons, and for those stated in Mr. Kaczmarek's two expert opinions, claimants are simply not entitled to the damages they seek. Thank you. That's the end of our opening statement.
Mr. President, this completes our opening statement. We renew our request that the tribunal dismiss this case for lack of jurisdiction, or in the alternative, if the tribunal decides to take jurisdiction, that the tribunal dismiss the claims on the merits, and we respectfully request costs and attorney's fees. Thank you very much.
Thank you. I'm sure we'll come back to that at the end of the session. Dr. Weiler.
Mr. President, just before I turn the podium, or in this case the on microphone, to Dr. Weiler, like my friend, I would like to reserve the right to make objections with respect to the overheads used. And in particular, and we may be quite wrong on this, but I'd like my friend to check to see whether or not they made use of the documents which they objected to us introducing into the record earlier, which were withdrawn. As far as we can tell, it seems like there were references to those documents. I apologize if I'm wrong on that, but that's a particular concern we had with respect to that. And if that's the case, then we'll deal with that later in the hearing. Thank you.
So we have two dueling reserved objections, or reserved right to make objections. Dr. Weiler, I understand that the microphone passes to you. We had scheduled in the daily schedule for today a break after the respondents' opening submissions by intention to allow a little bit of as it were, a pause before we have a change of voice. I'm quite content that we rise now for that pause for a change of voice, but I'm in your hands if you want to continue straight on or you would like a little bit of a pause. Could you turn the microphone on for the...
We'll take a short break.
So we'll rise for 15 minutes? Thank you. So we'll say a quarter to, or 4:45.
Thank you very much.